Thank you for joining us and taking the time in these crazy times to join us for our second bankruptcy webinar. This one is issues facing unsecured creditors and contract litigation in the oil field. I sort of would like to express my own personal hope that everyone is doing well and that people are staying safe in this crazy time in which we are all sort of working together, although somewhat separately. We definitely do look forward to seeing you all and visiting with you when the time is right. And with that, one other housekeeping matter I will mention, which is for those who joined us last week, the slides and recording are expected to be distributed today. There's a bit of a delay on the recording. So joining me today on our panel are three of my colleagues, two here from Houston and one from Wilmington, Delaware. Liz Klingensmith is a litigation partner here in Houston, and she partners with clients in the dispute resolution and litigation area, focusing principally, although not exclusively, on the oil and gas sector and energy sectors. Jasper Mason is a transactional colleague of mine here in Houston with a focus on the oil and gas sector. He's a board certified oil, gas, and mineral law specialist, representing typically E&P companies. And then my litigation partner in Wilmington, Delaware, focusing principally on bankruptcy and restructuring. Up here we have just a quick overview of what we're going to be talking about a bit today. Get ready for the ride, a bit of a context presentation, moving then to some of the unsecured creditors committee issues, including on the litigation side. And then we'll move a little bit to some of the contested matters and adversary proceeding issues that will be of importance, as well as specialized issues that you may face for bankruptcies filed actually in Delaware. Some of the producer midstream relationship issues, Bankr type stuff, and then finally some of the safe harbor contract disputes that you may find yourself facing if there is a bankruptcy upcoming. With that, I will turn it over to my colleague Liz.
Thank you, Paul. If I could have the next slide, please. First of all, I want to echo Paul's welcome to everyone. I hope this morning we are happily alone together and working and trying our best to stay connected. So welcome to this morning's presentation. Buckle up, you're in for a ride. Bankruptcy moves fast and litigation and bankruptcy moves at warp speed. Wanted to welcome all of you to today's webinar about bankruptcy litigation. We've done our level best to prepare comments to guide you through the uncertain days ahead so that you can feel more prepared for the ride. Please, as Ashley said at the beginning, please feel free to submit your questions over the course of the webinar, and we will try to save time at the end of our program to address those questions. So first I wanted to talk about how did we get here. There are two dominant factors that are crushing the oil and gas industry at both ends, on the supply side and also the demand side. There's an abundance of supply because we have gotten very good at what we do, and also as a result of the price war between Russia and OPEC. That was, I guess they came to some sort of resolution on Easter Sunday, but I don't think that there's enough. I don't think that there's enough confidence yet that the production cuts that are kind of developing is enough to steady the prices in light of the pandemic's evisceration of demand. So as a result, the price of oil has plummeted and made business that much harder for already over-leveraged companies to keep going. Facing borrowing-based redeterminations this spring, many companies will spiral into bankruptcy. And we're starting to see that already. Here are some of the companies that have recently sought the protection of the bankruptcy courts. Sheridan, Echo, Whiting, and Sklar have already filed for bankruptcy, and there are definitely more to come. And let's talk about what you can expect as an unsecured creditor. Next slide. So you've provided goods or services to a company and may already have some concern about your counterparty declaring bankruptcy, whether because of non-payment or payments are starting to slow. If the counterparty files for bankruptcy, you may find yourself holding unsecured debt. Typically, you'll receive notice in the mail from the federal court where the bankruptcy is pending if the debtor has identified you as an unsecured creditor with a claim. Next slide.
And Liz, let me just jump in there too. It's important as in this kind of environment too, to keep your ear to the ground to hear even before you get the notice, to try and sort of hear from the trade press or other means to know when someone files, which is often the case.
Right, that's right, Paul. Whether you receive notice of the bankruptcy or learn about it from general buzz in the market, you'll need to file a proof of claim by a specified deadline. The proof of claim is a relatively simple form. It's only 3 pages that you'll fill out and file with the court to prove up your claim against the debtor's estate. You may also have an opportunity to consider whether to serve on the Unsecured Creditors Committee. Next slide. So because unsecured creditors stand in line behind secured creditors and their claims are less likely to be paid in full, there is little incentive for individual unsecured creditors, absent a large claim, to hire individual representation in the bankruptcy. The cost would far outweigh the benefit. So absent statutory intervention, the unsecured creditors would likely be unrepresented and overlooked. So the Bankruptcy Code provides for the formation of a committee to negotiate on behalf of the class of unsecured creditors. Usually, the Office of the United States Trustee will issue a questionnaire to the debtors, 20 to 30 largest unsecured creditors, to gauge their interest in serving on the committee, and will subsequently organize a meeting of unsecured creditors for the purpose of forming an official committee. If you do not receive anything from the U.S. trustee, please know that any unsecured creditor who expresses a willingness to serve on the committee may be invited to participate in the meeting. The committee must have at least 3 representatives and no more than 7. And it has to be representative of the entire class of unsecured creditors. Consequently, the U.S. trustee may appoint additional committee members if there are distinct groups or interests within the class of unsecured creditors. The committee appointed pursuant to Section 11.02 of the Code is the official committee. The Code imparts specific duties and powers to the official committee through Section 11.03 of the Code. The committee is allowed to consult with the U.S. trustee or debtor about the administration of the case. They can participate in the formulation of a plan. They can also conduct an investigation of the debtor's pre- and post-petition acts, conduct, assets, liabilities, and financial condition, and they can perform such other services that are in the interest of all of the unsecured creditors. The committee has the absolute right to appear and be heard in any matter brought before the bankruptcy court and to intervene in any lawsuit involving the debtor filed in the bankruptcy court. The committee essentially serves as a watchdog for the interests of the unsecured creditors during the pendency of the bankruptcy. The Code authorizes the committee at a scheduled meeting in which a majority of the members are present to select one or more attorneys, accountants, or other agents to represent the committee. The bankruptcy estate pays for almost all committee professional fees and committee member expenses. Once the committee is formed and hires counsel, the day-to-day business of drafting pleadings, appearing in court, and negotiating on behalf of the committee will be conducted by the committee counsel. It's advantageous to retain counsel with industry experience, and for energy bankruptcies, that means finding a lawyer with significant experience in oil and gas law. Despite counsel's day-to-day role, the committee will always maintain the ultimate decision-making authority. So some of the benefits of serving as a committee member is that the committee members have the advantage of being the first to know. They're obliged to keep unsecured creditors informed and usually are the first to receive status reports from the committee's engaged professionals with the most up-to-date information about the case development, strategic next steps, the likelihood of liquidation or reorganization of the debtor's business, and the potential distribution of funds to be received by unsecured creditors. Committee members have impact on the administration of the bankruptcy case and actively negotiate and influence any plan of reorganization. Participation in case administration allows members to protect the interests of unsecured creditors and ensure their fair treatment. Given the economic climate and the probability of more bankruptcies to come, committee members also enjoy a front row seat to the bankruptcy process and can develop relationships with key bankruptcy professionals that will serve them going forward. Sounds like a pretty good deal, right? But there are some potential downsides to service as a committee member. Committee members have a fiduciary obligation to the class they represent. You have to be able to put the needs of the wider group before your own specific interests. However, that doesn't mean that members don't have the right to represent their own organization's interests in the bankruptcy case. When an issue impacting a specific committee member individually comes to a vote, that committee member should make that fact known, and depending on the circumstances, consider not participating in the discussion of that issue or vote related to that matter. Under no circumstance should committee members use their membership on the committee to obtain an advantage over other unsecured creditors. Time. Time may be the single biggest deterrent to serving on the committee. The amount of time required to properly serve as a member of a creditors committee is substantial. Tasks include multiple meetings a month, whether in person or over WebEx or by teleconference. In addition to the time spent just keeping up with the case, and the case can be long, anywhere from 6 months to a year or more. It's a lot of time spent for a potentially small return, given that most creditors will only recoup a fraction of what they are owed. But that's not always the case. So this is a battle that I fight every day working from home with my 12-year-old, and some of you who are parents out there may also be fighting the Fortnite battle as well. But the lesson here is to be ready for battle. Litigation in bankruptcy is lightning fast. With very little notice, counsel may be flying across the country to depose witnesses. Broad discovery requests and responses move at warp speed. For example, Rule 2004 permits any party in interest to use discovery to seek discovery from any entity relating to the act's conduct or property or to the liabilities and financial condition of the debtor or to any matter that may affect the administration of the debtor's estate or the debtor's right to a discharge. It's essentially a court-ordered fishing expedition. And because the bankruptcy court is a court of equity, the limited value of assets may be in decline and the interest to all creditors in the resolution of the case. The discovery related to these complex issues and high-stakes claims is condensed into a shortened time frame of weeks or even less. The Unsecured Creditors Committee, with the help of counsel, reviews claims filed in the bankruptcy to determine whether to challenge the validity of any alleged debt. The committee challenges disputable claims to maximize the pool of money left over for distribution to the unsecured creditors. And sometimes, through warrants or other mechanisms, you can recover 100 cents on the dollar on behalf of the committee. For example, in 2014, a secured creditor offered to buy Fisker Automotive out of bankruptcy, leaving the unsecured creditors with a small fraction of what they were owed. The committee fought hard against the proposed sale and argued for a competitive bidding process. As a result of the committee's work, the bidding process ended up resulting in a much higher bid and a significant increased recovery for the unsecured creditors. In another case, the Unsecured Creditors Committee successfully challenged a $46 million claim against the estate for the alleged breach of a natural gas liquids purchasing contract, which contained an exclusive remedy provision that arguably negated the entire claim. Following arguments and mediations, the parties settled the $46 million claim for a mere $5 million. The settlement increased the pool of dollars available to pay the unsecured creditors. In yet another matter, the Unsecured Creditors Committee argued against the validity of a $108 million claim arising from a rejected long-term gas processing contract based on a failure of the claimant to mitigate its damages, a duty arising from state law. Following argument, the claim settled for approximately 1/3 of the original amount, again increasing the value of the estate to the benefit of the unsecured creditors. Beyond challenging claims based on contract language or common law principles, there are instances where oil and gas expertise can play a substantial role in the committee's success in an oil and gas-related bankruptcy. For example, the committee can attack things like a creditor's alleged damage model based on well economics that really requires an understanding of commodity pricing, lease operating expenses, and production curves, or claims arising from technical design, procurement, and construction of oil field equipment that requires a special understanding of drainage, erosion, and other environmental issues specific to oil and gas, or claims arising from oil and gas property title defects, or joint operations, non-consent issues, or negligent oil field operations, including faulty hydraulic fracturing services. An experienced oil and gas lawyer can argue for the rejection of certain oil and gas contracts like gas processing agreements or management services agreements, asset purchase agreements, royalty agreements, or against certain pre-petition litigation claims related to oil and gas operations, oil and gas storage contracts, product defects, land disputes, royalties, and so much more. By successfully challenging these contracts and claims, the Unsecured Creditors Committee can save the estate tens of millions of dollars that may later be available for payment of unsecured claims. And with that, I'm going to turn it over to my partner, Kevin, to talk about contested matters and adversary proceedings in the bankruptcy. Kevin?
Thanks. Oh, thanks, Liz. I appreciate it. Interestingly enough, a lot of my work up in Delaware involves defending claims for creditors brought by the committee, whether in their own capacity or something that was given to them by the debtor, that they got authority to sue on the debtor's behalf. So I come at it from a little bit different perspective than you, Liz. With regard to bankruptcy litigation, it's very similar to civil litigation that you would see in other federal and state courts, but there are differences. One of the interesting things is the exclusive and original jurisdiction that the district court has over a bankruptcy case. The district court will usually refer the jurisdiction to the bankruptcy court, and that would include adversary proceedings and contested matters. The court's jurisdiction is really evolving. Probably a lot of you recall, I guess it was back in 2011, the Supreme Court in Stern versus Marshall changed the understanding of what a bankruptcy court's authority actually is. The Supreme Court held that some claims by the estate against people that hold proofs of claim were considered core proceedings. That was before, and then the Supreme Court held that that was unconstitutional, finding that the bankruptcy court, which is a non-Article III court, didn't have the constitutional authority to hear and determine those types of claims. Again, this is really an interesting and esoteric discussion, but really don't have time to dig into that today. Rather, I'm just really going to focus you on just bankruptcy litigation and how it might touch the energy sector. Okay, disputes between parties fall within two categories: adversary proceedings and contested matters. Both adversary proceedings and contested matters allow for discovery, allow for evidentiary hearings with testimony, and would require the court to make a finding of fact and conclusion of law. The contested matter, however, is a little bit different, that it does not require a summons and a complaint, permit counterclaims or third-party practice, and again, it usually doesn't involve the long, drawn-out pretrial procedure. The time requirements for a contested matter and responses are governed by the bankruptcy rules and depends on the type of contested matter you're dealing with, as well as the local rules of each particular bankruptcy court. Because contested matters are brought by a motion, courts usually decide them quicker than an adversary proceeding. And because of that, you'll sometimes see parties sparring over whether the relief sought should be in the form of an adversary or a contested matter. Next slide, please. Discovery without adversaries or contested matters, as Liz described, is found in the Rule 2004. And this is by a motion a party can seek in order for an examination of any entity. There doesn't even have to be a controversy in play at this point for 2004 to apply. As Liz mentioned, this is common for pre-filing discovery to determine whether there is any causes of action available. And it can be a fishing expedition. But once an adversary proceeding or a contested matter is started, 2004 no longer applies. Rather, the federal rules of civil procedure kick in, and to the extent made applicable by the bankruptcy rules themselves. Adversary proceedings are governed by Part 7 of the bankruptcy rules. These 7,000 rules look a lot like the federal rules of civil procedure. And as you can see, Rule 7001 offers a list of claims that relief must be made through an adversary. For example, the determination of the validity, priority, or extent of a lien, and the proceeding to recover money or property. Again, these are some things you might be seeing in the oil and gas sector. A contested matter usually starts with the filing of a motion for relief, but it can also be started once an objection or a response to the motion is filed. Sometimes even an oral response at the time of a hearing is sufficient, but usually the response deadline is fixed by the court. Discovery in a contested matter can begin right away. Often expedited discovery is needed so it can be completed before the hearing. Preferences are transfers of the debtor's property made by an insolvent debtor within 90 days of the filing of the petition, or 1 year if an insider is involved, like an officer or director of the debtor. These transfers are made on account of a pre-existing debt and favor certain creditors over others. A preferential transfer allows the creditor to receive more than that creditor would have received in a Chapter 7. The theory behind a preference recovery is to prevent a rush to the courthouse, and it provides equality of distribution among creditors. So creditors paid before the bankruptcy are not treated better than any others in the same class who were not paid. I recall several years ago, actually it was probably longer than that, a pro se preference defendant complained in front of the late Judge Walsh of the Delaware Bankruptcy Court that this law just isn't fair. Judge Walsh was sympathetic, but basically told him, you got to speak to your congressman, and they changed the law to change the law. The law is what it is. It's not fair to a creditor, but you have to deal with it. These are just the elements. The transfers can be avoided regardless of the debtor's motive or intent. All of these requirements are met. The transfer was of the debtor's interest in property. The transfer benefits a creditor. The transfer is on account of an antecedent debt. That is, the debt was incurred before the transfer. A transfer contemporaneous with or before the creation of the debt, by definition, isn't a preference. the debtor is insolvent. There's a 90-day rebuttable presumption of insolvency. If the defendant rebuts the presumption, then the plaintiff has the burden of proving that the debtor was insolvent at the time of that transfer. Here's where you might see a valuation battle with experts as to solvency. So this is the complicated portion and expensive portion of that piece of litigation. The transfer occurs within 90 days of the petition date. The look-back period, as I mentioned earlier, increases to a year if it's an insider. And then finally, the plaintiff needs to show that the creditor received a higher payout from the transfer than the creditor would have in a Chapter 7. Ordinary course of business is usually the most common affirmative defense. The creditor needs to show that the payment was in the ordinary course of business and either paid in the ordinary course of business between the parties or was made in the ordinary payment terms in that industry. The court will look at a number of factors. That would include prior course of dealings of the parties, the amount of the payment, the manner of the payment, whether the payment was the result of pressure by the creditor. This is a very fact-specific defense and can rely on statistical analysis as to timing and the manner of the payment. And this always reminds me of the Mark Twain quote, "There are lies, damn lies, and statistics." So you're dealing with some statistics here when you're defending a preference on the ordinary course. Subsequent extension of new value can also reduce the preference payment. New value that has not been paid for can offset against this liability. Advances of new value can be used as an offset against liability if those payments are themselves voidable. With contemporaneous exchange for new value, the defendant can reduce preference liability by showing, one, that the parties intended that the transfer be contemporaneous, the exchange was actually contemporaneous, and that the exchange was for new value. And new value could include money, goods, services, or new credit. There are other specific preference defenses that Paul was going to discuss at some point.
And maybe, Kevin, it just makes sense for me to jump in right here. Interestingly, of course, I think many of you know a lot of the work that I do on the bankruptcy side relates to the more to the trading and sort of forward contracts and derivatives related to various energy commodities. And the code provides some special provisions for that industry that I'll get into later in the presentation. But here's one of the first areas where it really does make a difference, what industry and what types of contracts we're talking about. Because, the safe harbor provisions of the bankruptcy code provide actually an additional defense, which is a much easier defense and frankly, a less fact-specific defense to preference actions and to fraudulent conveyance actions that Kevin will, I think, talk about next. But it's, always reminds me of the Mel Brooks film, It's Good to Be King. It's good to have defenses that some other folks don't have.
Thanks, Paul. I love any Mel Brooks movie, so you got me there. Let's move to fraudulent conveyances. So what exactly is a fraudulent conveyance? The definition is that it's a transfer of a debtor's interest in property or the incurrence of an obligation by the creditor that would be made within 2 years before the petition date. Sometimes that can be longer under state law. And it has to be done either to, one, hinder or delay or defraud creditors, or for inadequate consideration while the debtor was or became insolvent. Section 548 of the code allows the debtor to avoid these transactions, and then Section 550 allows the debtor to recover the transferred property and bring it back into the estate. Often, fraudulent transfers will be something that the committee or a post-petition litigation trust will pursue on behalf of the debtor. Next slide, please. All right, so what are the elements? Again, it is really comes down to that it's a transfer within the 2 years, and there can be actual fraud with actual intent to defraud, or constructive fraud where intent doesn't really matter. Next slide, please. For actual fraud, a plaintiff needs to show that the transfer was either of the debtor's interest in property or an obligation incurred by the debtor made with actual intent to hinder, delay, or defraud creditors. Again, this is a high bar, and a plaintiff can prove that by showing what they call badges of fraud. And that would include whether the transfer was to an insider, the debtor retained control of the property after the transfer was concealed, whether the debtor had been sued or there was a threat of suit before the transfer was not in the ordinary course of business, and whether the consideration was inadequate. The intent here must be shown by convincing evidence, but it can be inferred, and they are actionable simply because these transactions improperly deplete the property available for the distribution to creditors of the debtor. A plaintiff would need to show that the transfer was made or an obligation was incurred for less than the reasonably equivalent value when the debtor was insolvent or was rendered insolvent, was left with unreasonable small capital, or believed it would incur debts beyond the ability to pay as they matured. The code doesn't really define what reasonable equivalent value is. It's generally a fact question. When determining what value was reasonable, you look at from the debtor's perspective, what did they receive as opposed from the transferee, the value that they gave. Here's a chart that has just with some differences between preferences and fraudulent conveyances. As you can see, for the purpose, the intent, and who the transferee would be. Next slide is a continuation of this. Of note, in a preference, there is a presumption of insolvency in that 90-day look-back period. There's no presumption of insolvency with a fraudulent transfer. The plaintiff has to show that the debtor was insolvent. And proving or disproving insolvency can be an expensive proposition and will usually require expert testimony. Fraudulent conveyances can also be avoidable under state law. Under the bankruptcy code, the debtor, including assignees like the committee, can avoid the transfer of an interest of the debtor in property that is avoidable under applicable state law. So because of that, the look-back period is usually longer, could be 4 years under state law or more. The plaintiff will often add account into the complaint, raising a claim under state law. In anticipating some of your questions, and just to wrap up this segment, there are some pre-petition strategies that a creditor could use to limit exposure to a preference. One is accept the preference payments. Generally, it's better to have the money in your pocket and have someone chasing you than being a general unsecured creditor in a bankruptcy case. Go with the COD. You don't have an antecedent debt, and therefore there's no preference. Don't change billing procedures or policies once the debtor is in financial difficulty. Pressuring the debtor to pay faster is a problem because it is an action outside of the ordinary course. Ideally, the collection efforts would begin as soon as the debtor's payments start to slow down, as much before the preference period as possible. This would make the collection activity falling in that 90-day period be more in the ordinary course of business. And any changes in the billing procedure should be at least made uniformly across the business for all of its customers. Another method is applying payments to the most recent invoices. Now, keeping the payment date closer to the invoice date can help establish ordinary course of business. Managing the timing of the payment and the shipment can limit exposure. The new value defense can be asserted if goods are shipped after the payments are received from the debtor. Another thing is cash your checks promptly. They're sitting there, it just adds to the delay, and it might fall within the 90-day look-back period. Avoid post-dated checks. Again, that would be a flag that it's not ordinary. If possible, have the debtor pledge collateral to secure the debt, because payments to a fully secured creditor aren't preferences. Try to get an irrevocable letter of credit. If a cash payment isn't possible, a letter of credit from the debtor will guarantee the payment of any outstanding trade debts. And then finally, you could consider...
Standby letters of credit are good things too, and often dealt with in our business.
Right. And again, just to wrap up on this, consider credit insurance. There is some of that available. With that, I think I'm done, and I'm going to turn the mic over to Jasper Mason, who's going to give you some of the hot topics in the sector.
Kevin, thanks for that. And though we're well on our way in the presentation, let me just take a moment to welcome everybody and thank everyone for attending and for your kind attention this morning. Kevin's right. I'll talk about some hot topics, specifically this morning vis-a-vis the ability of a debtor or the reluctance of a creditor to have a contract rejected during the bankruptcy proceeding. Those of you who are familiar with the subject will remember the Sabine cases from a couple of years ago, which we will cover in a little bit of detail. And most recently, the holding out of the Southern District of Texas Bankruptcy Court and the Alta Mesa proceedings. We'll talk about how those two situations can be distinguished, what might have changed, and some strategies for protecting yourself if you don't wish to have the contract rejected, and the strategies under which the party wishing to have the contract rejected employed. So to give an idea, if we could have the next slide, please, of why these contracts matter and what sort of context in which they usually arise. For producers to get their oil and gas to market, the production must usually be gathered and delivered to a pipeline that transports the production to a producer. Producers may dedicate their reserves in a lease or other real property to long-term gathering contracts with these midstream companies, who are thereby guaranteed a predictable cash flow, or at least an ostensibly predictable cash flow, that they can use to borrow money needed to construct these very expensive and infrastructurally heavy gathering systems. But what happens, as the preceding sentence may have alluded to, what happens when prices decline? Producers are often saddled with paying the gathering fees for production that's worth far less. In some markets, the gathering costs for natural gas are exceeding the price the producer can get for the gas. And leasehold issues and production and paying quantities aside, sometimes producers may turn to bankruptcy law to try to rid themselves of what they may perceive or categorize as onerous gathering agreements in order to get some relief for the estate. How the success of that strategy or the ability to defend against that strategy depends primarily upon how that interest is categorized. Is it an executory contract? Is it a real property interest? To take them in the reverse order of the slide that's in front of you, an executory contract, for those that don't know, pretty simple concept. It's a contract between a debtor and another party under which both sides will still have important performance remaining. To put that another way, if either side stopped performing the contract, it would be an actual breach of contract. Executory contracts, almost without exception, are able to be rejected. Sections 365 and 363 of the Bankruptcy Code have different ways of treating that, and we'll talk about that in just a moment. If it's a real property interest, on the other hand, the calculus changes, and part of how it changes is whether that real property interest is categorized as a covenant running with the land. If so, it won't be able to be rejected by a successor in interest. And those of you who hated 1L property, I'll welcome you back for a quick flashback. We'll talk about the basics of what that means before we get into the case discussions, just for a quick refresher. A covenant running with the land is an interest in a real property. It's not a freehold estate like the surface or mineral fee or the oil and gas leasehold estate, but it's a right or an obligation that's primarily attached to the land rather than being contractual in nature. And as such, a covenant running with the land, therefore, does not constitute an executory contract under 365 or 363. And therefore, a debtor in bankruptcy shouldn't be able to sell the property free and clear of such a covenant nor reject it as part of the bankruptcy proceeding. A covenant runs with the land. We'll talk about what that means. It runs with the land when it, first of all, touches and concerns the land. It relates to a thing in existence, or it specifically binds the parties and their assigns. The original parties intended it to run with the land, and the successor to the burden has notice. So what is this running with the land? It has its roots in English law. It's continued into American common law. It's a right or an obligation that's said to run with the land when the benefit or the burden of the covenant passes automatically to the subsequent owners of the land or interest in land to which the benefit or burden applies. How does all of this, okay, end of flashback, no more 1L property, I promise, for the rest of my part of the proceedings. How do these concepts, these fundamental concepts, apply themselves in the case law, and how do we find their efficacy in either preserving or rejecting these contracts? Well, first of all, we'll go with the Sabine cases, and there are two, so we'll refer to them as Sabine 1 and 2. On March 8th of 2016, the Bankruptcy Court in the Southern District of New York, Second Circuit, applying Texas law, importantly, concludes that it's precluded from making a final decision regarding whether the covenants at issue in the Sabine case are, if they are in fact covenants that run with the land, because the issues raised in the context of a motion to reject, that for some procedural inadequacies, it wasn't accompanied by a simultaneous adversary proceeding. Nonetheless, the court holds that Sabine is authorized to reject these gathering agreements, these production agreements, concluding that their decision to reject those agreements is really just a reasonable exercise of the business judgment rule. But the court doesn't stop there, importantly. Though they're unable to make a final determination on the covenant issue, the court includes this sort of non-binding analysis, as the court phrases it, of whether the relevant covenants running with the land under Texas law, and they state a preliminary finding that none of the covenants run with the land, either as a real covenant or as an equitable servitude, another type of burden on the property. And so what has to happen next, of course, to cure these procedural inadequacies is the next slide, please. Sabine 2, if you will. So after the Sabine 1 proclamation, Sabine commences these adversary proceedings seeking a declaratory judgment that the covenants in controversy don't constitute covenants running with the land. And on May 3rd, 2016, the same bankruptcy court grants Sabine's motions, holding that neither the acreage commitments or the agreements to pay gathering fees constitute covenants running with the land as either real covenants or equitable servitudes under Texas. So that they stuck with their earlier preliminary findings and acted on them. And at the core of the decision in Sabine 2 is the bankruptcy court's conclusion that, one, these covenants in issue do not satisfy the touch and concern element of the covenant running with the land test, at least not under Texas law. And secondly, assuming if horizontal privity of a state is a required element of the covenant running with the land test in Texas, that horizontal privity is not present with regard to these agreements. And so the takeaway from this case is, if we could have the next slide, please. The takeaway from this case is that because they weren't found to be real covenants running with the land, they were able to be and were discharged in the bankruptcy proceedings, leaving the creditors to wonder, well, what would a contract need to look like so that it would not be rejectable in these context proceedings. And so many commentators have opined, and law review authors and professors and practitioners have written about this for the past couple of years. But just a couple of months ago, pre-COVID-19, if anybody can remember that far ago, back in that world we lived in December, the U.S. Bankruptcy Court for the Southern District of Texas, here across the street from us, with Judge Isger presiding, this time applying Oklahoma law, enters a memorandum opinion and an order finding that midstream gathering agreements create covenants running with the land under Oklahoma law that can't be rejected by bankrupt debtors. This, of course, departs from that 2016 decision in Sabine, which did hold that a debtor could reject midstream gathering agreements because it didn't create a real covenant that ran with the land under Texas law. So without getting too much into the differences between jurisdictions, between not parsing words between Texas and Oklahoma, get to the meat, the heart of how this came down the way it did and how things have changed. So while the Sabine oil decision found that agreements failed to satisfy both the touch and concern and the privity elements, Judge Isger found that both of those elements were present in the debtor's midstream agreements. The court explained that a covenant touches and concerns the land when it, quote, requires the performance of a physical act upon the land that directly benefits the landowner. The gathering agreements met that requirement because the midstream party in this case used its surface easement to build a more modern gathering system, which enhanced the value of the leases. And of course, the leases, the interest came through the debtor's estate. If we could go to the next slide, please. Regarding the privity element, Judge Isger observed that the debtor's leases granted them the easements to develop hydrocarbons and that the debtors granted a portion of those very same easements to the midstream entity to provide the gathering services. So in holding that the easements directly burdened the debtor's interest, Judge Isger noted that, quote, contrary to the holding in Sabine, the surface easements directly affect the lessee's underlying mineral interest because without those surface easements, the lessee could not capture reserve hydrocarbons. There's a little controversy on that statement, but that's the court's holding. And that finally, and extremely importantly, based on the express language of the agreements themselves, it was clear that the parties intended the agreements to run with the land. There was explicit language specific to that point. So if we could go to the next slide, please. We'll wrap up with some takeaways. Ultimatum sheds light on the importance of drafting and structuring contracts that will withstand rejection under Section 365 of the Bankruptcy Code, since under its analysis anyway, the surface easement aspects of an oil and gas lease on which the gatherer is relying, they're an integral component of the covenant running with the land, and they help establish that privity of estate requirement. Moreover, midstream gathering agreements should also clearly stipulate the party's intent to create a real property covenant that runs with the land, that is binding on successors and interests, that anyone who takes subject to those contracts does so on notice of that burden. In Ultimata, each agreement expressly stated that it was a covenant running with the land, and it required, importantly, that those dedications be recorded. So that recordation, and just to downshift into Texas law for a minute, Texas has an interesting statute in the property code that states that proper recording is effective notice to the world of the existence of a burden. And so in putting into the context of the contracts, both that they intended them to be covenants running with the land and a requirement that they be recorded, they were more successful in making sure that the debtor wasn't able to reject those contracts as part of the bankruptcy proceedings. So that's a short overview, admittedly, of some of the differences, but I hope it categorizes and explains some of the interest or some of the differences in how these things will be treated by the bankruptcy court if you're on the side of the equation that hopes to have these contracts preserved. Part of the creditors committee perhaps be sure to argue those things that there's a real property interest there, that they aren't merely executory contracts. If on the other hand, the goal is to have them excluded from the bankruptcy estate, try to focus on the executory contract nature and any sort of performance that by either party wouldn't be rendered, constituting a breach of contract. So that'll conclude my portion of the presentation. If I may, I'll reintroduce my colleague Paul, who will finish up today's remarks with some respect to some of the more common disputes that arise in bankruptcies and in the safe harbor context. Thanks so much.
Thanks, Jasper. And actually, we have a question from a real quick question for you, which is, doesn't it seem that the judge here in the Southern District of Texas maybe remembers his real property law or took it more recently? Oh, wait, that's a question. Never mind. Okay, moving on.
Is it acceptable for a lawyer to plead the fifth?
Exactly. So anyway, I'm going to sort of talk a little bit, and I'm cognizant of the time that we have about, based on our schedule, about 6 minutes left. I will try and sort of cover just the highlights in the safe harbor slides that I have here, but to be aware, it probably will run a bit over. If you need to drop off, of course, feel free to do so. We are recording it, and we'll get you the recording as soon as it becomes available. So I'm going to talk a little bit about some of the fairly specialized disputes that we often see in the context of a safe harbor contracts in bankruptcy. I think a number of folks in the energy space, up and down the oil and gas sector chain, as well as on the power side and coal side, with respect to energy companies when they file, these are issues that come up a good bit. And frankly, oftentimes the dollars involved in some of the complexity with respect to forward contracts and swap agreements are such that it's pretty uncommon for folks not to retain counsel for these types of claims. I'll go quickly just to give a refresher and background on the safe harbor provisions of the Bankruptcy Code. So, as I think Kevin alluded to, and as we talked a bit about earlier, of course, when someone files for bankruptcy, the automatic stay generally prevents folks from terminating their contracts, as well as gives the debtor a significant right to assume or reject executory contracts. And here's the part of the presentation where we get to say, well, yes, but not for us. Under the safe harbor provisions, the counterparty to a contract with the debtor, if it's a forward contract or a swap or a master netting agreement, among other types of agreements, the same analysis does not apply. The Bankruptcy Code allows forward contract participants and forward contract merchants and swap agreement participants, as well as master netting agreement participants, to exercise their existing contractual rights to terminate, liquidate, and accelerate their contracts, as well as to foreclose on the collateral they have with respect to those contracts. So basically, if you have a contract that says that a bankruptcy event is embedded in default, which most of these do, then you actually do have the right to terminate your contracts. And usually what that means is then for these trading contracts, you would move to a termination valuation or coming up with a settlement amount. I've already mentioned that they have these defenses from the preference actions as well as from the constructive fraudulent transfer claims. So I'll just sort of hit the highlights here. The reason that we have these protections is because there was a real concern on the part of Congress that you not have a domino effect, that for those who participate in the commodity markets on the forward contract side, or the financial markets on the swap side, et cetera, not have someone in that chain who goes bankrupt and have it basically cause a domino effect, basically create havoc in the financial sector, commodity sector. Let's see, I will sort of note that while the rights under the safe harbor provisions allow you to terminate and liquidate your contracts, it doesn't actually eliminate the debtor's right to assume or reject contracts, assuming that if that contract is still in place. So if you have an executory contract, it's a forward contract, and you don't terminate it, the debtor is left with exactly the same rights to determine whether to assume or reject. A couple other key points. The contractual rights that we talk about with respect to safe harbors, they aren't created by the Bankruptcy Code. You have to have the right itself to terminate and liquidate, be that from the contract itself, from a rule on an exchange, or interestingly from the contract law merchant. But it doesn't create the rights. Also, you should note that bankruptcy courts tend to be a bit more unaccustomed to these types of rights, and so you sometimes get unpredictable results, and/or these courts take a somewhat narrower view. So let's, on the next slide, let's go ahead and start talking about the actual disputes we see. One of the most common disputes that we see in these bankruptcies with respect to forward contracts, and the most pertinent dispute we see, actually sort of is centered on the actual termination and valuation. So if you have a forward contract or a swap with a debtor, you should expect that when you sort of deliver your termination statement that has the settlement amount, you should expect that there will be a dispute over that number, unless in the off chance you deliver a number more favorable to the debtor than it thinks. But even then, sometimes you get that kind of dispute. You should expect that the debtor itself has made a determination of what it thinks the reasonable valuation of the positions are, and will sort of use a host of arguments as to why your valuation is incorrect. This can be things like, you didn't get enough quotes. The quotes you got weren't reasonable. Well, yes, you followed the methodologies that you were supposed to, but you know, the people who were giving you the quotes, the market makers, they knew that these were quotes for X filing for bankruptcy, and therefore they aren't real quotes. Or, yeah, because of our bankruptcy, there weren't enough participants in the market, and the market is too illiquid. And then, frankly, debtors will go through with a fine-tooth comb your contracts to try and come up with ways in which you didn't follow the procedures in the contract accurately. Having on one occasion represented a debtor, an energy trading set of companies debtor, we did that quite significantly as we were trying to liquidate about a $4 billion trading portfolio through bankruptcy and do it in a manner as favorably as we could to the debtor. And then sometimes you'll see that debtors will say, no, you didn't have a right to terminate, therefore your termination was itself a default, so we are the non-defaulting party. All right. If you're going to terminate, you need to make that decision quickly, otherwise you may face a challenge as to your right to terminate under the safe harbors. And then finally, just two critical pieces of advice. Preparing for going out and getting your quotes and doing the calculation really is critical. You really need to go through your contracts and figure out what it is you need to do. And then because of the bankruptcy process, a dispute over termination value, particularly if it's a formal adversary proceeding, or if it's a contested matter or a challenge to the proof of claim, that can happen months or years after the actual process. So be sure you preserve the records and a description of what you did. Next slide. Okay. One of the when I sort of say, gee, you need to really go through your contracts carefully to see what the process is you need to follow. I think it's useful to sort of lay out a few examples in which even master agreements for the same commodity can be different depending on what your master agreement is. So under the most recent LEAP agreement with respect to crude oil, I sort of lay out portions of the termination and liquidation provisions and have highlighted the most critical part. And then here the key provision is that in doing the valuation, the performing party determine the market value. Let's do it in a commercially reasonable manner, and may consider, among other valuations, quotations from leading dealers in swap contracts or physical trading, similar sales or purchases, or any other bona fide third-party offers, all adjusted to the length of the term, relevant dates, et cetera, et cetera. So under the LEAP, a great deal of flexibility in determining the valuation or the market value of the terminated forward contracts. If we go over here on the other side, I guess no, not new slide, just the other side of the same slide. This is actually from the 93 Conoco GTCs, which didn't come through. When you're doing a determination, it's actually from the Platts Oil Brand Price Index. So here, if your contracts are governed by the Conoco GTCs, which is pretty common, you'd actually have to go to Platts. And if you have some transactions under Elite, some under Platts, they are different methodologies, so you need to be pretty careful and precise. Next slide. Of course, the classic example of the point I'm making is some of the differences between the changes on the 2002 ISDA side, which of course is for swaps and derivatives, or if you have some of the annexes also on the physical side for commodities. The difference between the closeout amount definition in the 2002 ISDA and the market quotation methodology in the 92. So under the 2002, you can again see very, very broad, great deal of flexibility. Come up with the amount of the losses or costs that would have been incurred in the circumstances or gains that the non-defaulting party would basically, it would be the economic equivalent that would put them in the same position they would have been had the but for the occurrence of the early termination. And it goes through below and sort of says you can get quotations for replacement transactions, information from market data, your own internal information, i.e. your own forward curves, et cetera, et cetera. And so it's a very long-winded way of saying you can take a look at a lot of different things and come up with your forward valuation, although it does have to be done in a commercially reasonable way that would lead to a commercially reasonable result. Next slide. Now contrast that with the most typical valuation methodology under the 92 ISDA, which is still very common and prevalent in the derivatives business. It's the market quotation method in which you go out, you seek market quotations from reference market makers, i.e. someone who is in the business of making a market for that particular type of commodity. And if you get more than 3 quotes, you take out the high and you kick out the high and the low when you average them. If you have 3 quotes, you take the middle quote, and if you have less than 3 quotes, then you don't satisfy the market quotation methodology. So again, on the 2002 side, huge flexibility. 92 side, much more confined and specific. Next slide. And again, looking at the 92 is that you have in some instances people avoided the market quotation and went with a loss methodology, which again is pretty flexible, but maybe not quite as flexible as the closeout method. And then for those who have been in the industry a while and recall, under the 92, you always had the choice of the first method versus second method. And again, not something you would even see under the 2002 ISDA. The first method being the if you have a forward settlement amount for your contracts and positions that is in the benefit of the debtor or to the defaulting party, then the forward settlement amount is 0. And for years, that was actually always a big argument as to whether that was even enforceable. Anyway, totally eliminated in the 2002. So next slide. So that's probably going to be your biggest bone of contention in these kind of bankruptcies, and that's sort of what is the valuation. The kind of an additional dispute, and I'll go quickly through the remaining few slides. We have started to see disputes, and I think we'll likely see more in the future, regarding the scope of the coverage of is the service or good that you're providing actually qualified as a forward contract. There was significant cases in the early 2000s related to, whether your traditional commodity type contract, forward contracts qualified, yes, natural gas, electricity, crude oil products, etc. Yes, coal, yes. But if you look at how broad the definition is of a forward contract, it's not just the commodity itself, but the good, but it's the article, service, right, or interest, which is presently or in the future becomes the subject of dealing in the forward contract trade, or the product or byproduct thereof. So when you have contracts that involve the sale of a commodity, but also include other services such as coal handling, if you're putting whatever chemicals it is to prevent coal from going bad or from freezing, etc., are those covered by the forward contract? Those are the kind of disputes I think we'll also see in the future. Similar issues could arise on the swap side. Next slide. You used to, of course, always have significant disputes over set-off, particularly triangular set-off. Here, just a reminder, under the current case law, triangular set-off is not enforceable under the bankruptcy code, despite what your contract may say, and despite the fact that it's a forward contract. So the disputes you might well now see relate more to what is bilateral if you have a parent guarantee as well as a principal obligation from a parent. Are those that create mutuality? Are those bilateral obligations, and are they mutual? In many cases, the answer is no. So you can still face some issues on the setup side. Next slide. Here, I won't go through these in any detail, additional types of contested matters you may see, but I will highlight the first bullet on this slide, which is in bankruptcy, when it comes to disputes, technicalities matter. You'll get disputes if you don't follow the technicalities of your contract. If, say, you have a form of guarantee from the debtor, but it's not signed, technicalities matter. So yeah, and with that, I believe, next slide, I will turn it over, yes, Liz, to bring us on home.
So thank you, Paul and Jasper and Kevin, for your comments this morning, and thank you to all of our participants in this webinar. It doesn't look like we have any questions, but if there are any questions following the conclusion of our program here today, please feel free to reach out to any one of us. We'd be happy to answer your questions following the program. Everyone stay safe out there, and we hope to see you soon. Thanks so much.